Hello everyone, welcome to AptiPlus Academy for Civil Services. Today I am here for a daily news and editorial analysis for past 3 days, and today I'll be covering a past 3 days current affairs, which are Thursday, Friday and Saturday. And these 3 days current affairs are going to be very important because I have picked up the most important current affairs topic which were there in news, especially in the Hindu and Indian Express. And this editorial analysis is going to be important for all the government exams in India, and especially for the UPSC Civil Services prelims, mains and interview process. So without further delay, let us begin the analysis. And to your kind information that at AptiPlus we cover the current affairs of the entire week in 2 days, and the first 3 days current affairs, which is Monday, Tuesday and Wednesday, is being covered by Sahil sir, and other 3 days current affairs is being covered by me. So watch the current affairs and do not miss any current affairs. So having said that, let us begin the analysis. So first news of analysis for today is very important, and this news is about the what constitutes a money bill. So money bill, as we all know, is talked about in Article 110 of the Constitution of India. So the money bill is in news because recently it has been seen that the government of India or the parliament has been passing several bills through the money bill route, and this process is being criticized by many people and the critics in India. For this reason, this topic is in news. So money bill especially is again in news this time because this time Supreme Court has decided to hear the reason why what constitutes the money bill. So money bill, the context of the news is that Supreme Court agrees to hear the challenges to the government's passage of several laws through money bill route. So it has been criticized in several instances that the government of India has been using the money bill to bypass the Rajya Sabha. As we all know that Rajya Sabha, the permission of Rajya Sabha or the approval of Rajya Sabha is not required in case of money bill. So money bill is basically introduced in Lok Sabha only. So if the government has majority in Lok Sabha and government do not have the majority in Rajya Sabha, then in that case the government might take the route of the money bill. So to bypass the Rajya Sabha. So that process is being questioned by the people, whether that process is constitutional or not, whether considering ordinary bill as a money bill is against the constitutional framework or not. That will be decided by Supreme Court in the 7-judge bench case. So this time Supreme Court will decide the case through 7-judge. So 7-judge. Why 7-judge? Because previously Supreme Court had already ruled in favor of government of India or in favor of various bills in parliament which were passed through money bill route. For instance, in Puttaswamy judgment, Supreme Court of India upheld the validity of the Aadhaar Act. And in the Aadhaar Act, Supreme Court of India gave the test of proportionality. So test of proportionality was given in Puttaswamy judgment. Test of proportionality. So test of proportionality basically talks about what constitutes goodness in the bill. So if a bill whether passed through the money bill route or any other route, if that bill has the aim to do the greater good in the society, then that bill would pass the test of proportionality. So the test of proportionality was given in the case which is called the Puttaswamy judgment. We will know about that case in detail as well. Puttaswamy judgment. This judgment is very important. So this is the basic context why this topic was in news. And previously as well, Supreme Court of India had heard or had ruled in various cases, as we just discussed about the money bill. But in previous cases, Supreme Court of India had given verdict on the money bill. with the 5 judge bench, ठीक है, but this time a higher bench which is 7 judge bench would decide the case. So this is the context of the news, and the Supreme Court had formed the 7 judge bench, constitutional bench, which is on October 2023. So this bench was formed earlier, but this time Supreme Court has decided that they will be hearing the case, ठीक है. So the basic background of this money bill lies in the issues of the Finance Act 2017. So Finance Act is the core issue which is being protested by the people, because the Finance Act of 2017 was a debatable topic, because in this Finance Act the government of India or the ruling party had altered the appointments of 19 key judicial tribunals, including the National Green Tribunal and Central Administrative Tribunal, which is CAT. So in these tribunals, the central government wished to change the appointment process, ठीक है. So central government wished to take more power in the appointment process of the tribunals or the head of the tribunals. So basically through this Finance Act of 2017, the government of India gave the Parliament of India tried to give more power to the central government in the appointment process of these tribunals. So for this reason, this act was criticized by the people, and for this reason this Finance Act is again questionable, ठीक है. So this is the main debate of the issue regarding the money bill, and the critics argue that the Aadhaar bill was categorized as money bill to extend the executive control over the institutions which are tribunals by altering the composition of the selection committees and vastly downgrading the qualification and experience required to the staff of these bodies, ठीक है. So Aadhaar bill, ठीक है. So Aadhaar Act, now it is an act because it has already got the assent of the President of India, ठीक है. So Aadhaar Act was basically passed through the route of Finance Act 2017, ठीक है. So Finance Act was introduced during the budget session of 2017, and through this Finance Act the Aadhaar bill was introduced, ठीक है. So Aadhaar bill in this way got the status of the money bill, ठीक है. So through these bills the status of the tribunals were changed. So for this reason this Finance Act was criticized by people, and other petitioners argued that the various provisions in the Finance Act 2017 were unrelated to the fiscal subjects listed in Article 110, ठीक है. We'll discuss about the Article 110 and its provisions as well, but the money bill which Article 110 defines is the only provisions which is contained in the Article 110. So basically people argue that the provisions contained in various acts which were passed in the Parliament through money bill route did not contain did not satisfy the provisions of the money bill under Article 110. So this is again one of the important criticism, ठीक है. And although the Supreme Court had quashed some amendments introduced by the law, it did not strike down the Finance Act, entire Finance Act. So we talked about various judgments. For instance, we talked about the Puttaswamy judgment, ठीक है, and there is Santa Kumar judgment as well. So various judgments basically quashed or nullified various the rulings of the Supreme Court of India. For instance, the tribunals related ruling, tribunals related bill was also nullified by the Supreme Court of India, but entire Finance Act was not nullified by Supreme Court of India, ठीक है. So for this reason critics believe that Finance Act 2017 should entirely be abolished, ठीक है. So that is again an important challenge that the critics are giving to the Supreme Court of India, ठीक है. So this is an important point. And even the electoral bond scheme case, the Supreme Court had struck down the scheme and amendments introduced to the Finance Act. So electoral bond scheme, as we all know, was introduced as the money bill. So electoral bond scheme was recently invalidated by the Supreme Court of India, ठीक है. So So electoral bond scheme was also introduced as a money bill through the Finance Act of 2017. So if the Supreme Court of India had nullified entire Finance Act, they would not have to pass the judgments again and again. Okay. So for this reason, people are criticizing the government and the Supreme Court of India, saying that the Finance Act 2017 should have been entirely nullified. Okay. So this is another criticism. And other important acts passed by the Parliament of India as money bills includes the Money Laundering Prevention of Money Laundering Act 2002, which is PMLA, okay, and Aadhaar Act of 2017, we talked about it, and there is Foreign Contributions Regulations Act of 2010. So these were all acts which were passed by the Parliament of India as money bills. So these we can say is valid till now. These acts are valid till now because there has not been the judicial review of all the provisions of these acts, okay? But the provisions of these acts will depend on the verdict of the Supreme Court of India that will come in few days or in few months. Okay. So this is the background of the Finance Act and why people are criticizing the Finance Act. And talking about the important cases which relates to the money bill, we need to know three important judgments. Okay. The first is Puttaswamy judgment. We talked about it. Okay. We'll discuss about it again. And there is Roger Matthew case. Okay. And third one is the Chandra Kumar case. Okay. So these three important cases are very important for the UPSC prelims, and in mains as well you can quote these important cases. And in Roger Matthew versus South Indian Bank Limited and others case 2019, Supreme Court basically struck down the tribunal, appellate tribunal and other authorities qualifications, experience and other conditions of service matters rule 2017 that altered the structures and functions of various tribunals. We talked about it, okay? And this tribunal, appellate tribunal and other tribunals act or the rules 2017 was also introduced through the Finance Act of 2017. Okay? So Finance Act of 2017 also introduced this provision, but this provision of the Finance Act was nullified by Supreme Court of India in Roger Matthew case, and it had given the center power to govern the appointments, removal of the conditions and the terms of service of judicial tribunals, including various tribunals. Okay? So for this reason, this act was against the constitutional framework of the Constitution of India. So for this reason, Supreme Court of India nullified this act, okay, these rules. So for this reason, this judgment is important. And now moving on to next important judgment, which is Puttaswamy judgment. We discussed about it, okay? Case Puttaswamy judgment versus Union of India case is very relevant, and this case is also important because of right to privacy. Okay? So right to privacy was held to be intrinsic part of the fundamental rights as per this Puttaswamy versus Union of India case. Okay? So for this reason, this article, judgment is important. And right to privacy as contained in Article 14, Article 19, Article 14 talks about right to equality, Article 19 talks about right to freedom of speech, and Article 21 which talks about right to life and personal liberty. So these three articles contain the right to privacy, and they are very important and fundamental in governance of country. Okay? So this was the judgment of the Puttaswamy versus Union of India case. And another judgment of this case relates to Aadhaar Act. Okay? So Aadhaar Act, we discussed about it. In this case, Supreme Court of India talked about the test of proportionality, whether the certain government scheme or certain act of the parliament constitutes the greater good for the society or not. So that will be decided by the Supreme Court of India. Okay. So Supreme Court upheld the constitutional validity of Aadhaar Targeted Delivery of Financial and Other Subsidies, Benefits and Services Act 2016. Okay. So validity of the Aadhaar Act was upheld by Supreme Court of India in this judgment. Okay. So this is very, very important. And Supreme Court also declared its legislative passes as money bill was legal, valid, although the Justice Chandrachud dissented. So this is not quite important. You don't need to remember the judge who dissented. But out of 5 judges, 4 judges ruled that the Aadhaar Act was good for the people of India. Aadhaar Act was valid. To pass Aadhaar Act as money bill was valid. So this was the opinion of 4 judges, but one judge who was the Justice Chandrachud. So Justice D.Y. Chandrachud, who is the current Supreme Court judge, basically dissented the passing of Aadhaar as the money bill. So with the 4:1 ratio judgment, this act was considered legal. So this is an important point regarding the Supreme Court case in the Puttaswamy versus Union of India case, and various test was given, and Supreme Court of India decided that which constitutes the valid or which constitutes not valid as per this test of proportionality. For instance, the Aadhaar link, whether necessary or not necessary, was also decided by the Supreme Court of India in this judgment. Subsidies and benefits, for instance, to give subsidies, to give benefits to the people was held to be valid, and in this case Aadhaar has to be linked with some bank account. So for instance, to give the benefit of the MG Narega to the people, to give the daily wage of MG Narega to the people, Aadhaar has to be linked with the bank account of the people. So that is the valid case. That is you can see by the green color here. Linking of PAN with the Aadhaar card, that is also mandatory. And Aadhaar cannot insist on Aadhaar. School admissions cannot insist on Aadhaar. There is no requirement of mandatory linking or mandatorily asking for the Aadhaar card in the admission of schools. NEET, JEE, UGC, CBSE, जितने भी सेंट्रल गवर्नमेंट के एग्जाम्स हैं, there is no requirement of Aadhaar card. And in private companies as well, Aadhaar card is not required. So in these cases, Aadhaar card is not required. So Supreme Court basically decided these things based on the criteria that whether that particular scheme, that ambition of the government is fulfilling the basic good of the people or not. Greater good of the people or not. So this is the test of proportionality. So based on the test of proportionality, this Aadhaar card, the Aadhaar Act was held to be constitutional by Supreme Court of India. So you need to know about this judgment. So these were all important facts about the Puttaswamy judgment. Now moving on to next important judgment, which is the Chandrakumar case. So Chandrakumar case is again important. And in this Chandrakumar case, Supreme Court ruled that judicial review is fundamental, and they are necessary aspect of the constitution, and jurisdictional verdict of the tribunals are subject to judicial review. So in this judgment, basically Supreme Court of India held that the verdict of the tribunals are subject to judicial review. So article so far as the tribunals are concerned, there are 2 types of tribunals. One is administrative tribunals. Second one is the other type of tribunals. And administrative tribunals are basically established by Article 323A of the Constitution of India, and the other type of tribunals are established by Article 323 subclause B of the Constitution of India. So these 2 tribunals are basically contained in the article 323 subclause A and B, and the 42nd Amendment Act provided for the tribunals in India. And tribunals are basically established by the Parliament of India for the particular purpose, to solve particular purpose. For instance, to solve the issues of the income tax, there is income tax appellate tribunal. To solve the issues of the civil servants, there is central administrative tribunals. Okay, so these type of tribunals are created by the Parliament under article 323 and 323b. Okay, but as per these articles, state legislature or the Parliament, okay, so article 323, you need to remember one point, that under article 323 only the central government, only the Parliament of India can establish the tribunals. Okay, not the central government, but only the Parliament can establish the tribunals. And under article 323b, state legislature as well as the Parliament of India can establish the tribunals for other purposes. Okay, so you have to remember this point. And it is written in these two articles that state legislature or Parliament of India can exclude the jurisdiction of other courts on the matters of the tribunal. Okay, that means the judicial verdict or the matters related to the tribunals are outside to the judicial review. So that can be exclusively written in the bill which is passed by the Parliament or the state legislature. But as per this Chandra Kumar case, the judicial verdict, judicial review is the basic feature of the Constitution of India. So for this reason, even if the verdict is passed by the judicial tribunal or not, that is subject to the judicial review. So that is an important point. So judicial review was held to be the basic structure of the Constitution of India in this case. So judicial review, judicial review was held to be the basic structure of the Constitution of India. So basic structure doctrine, what it says is that there are some basic structures, there are some important features which are integral part of the Constitution, which cannot be taken away even by the amendments under the article 368 of the Constitution of India. So basic features of the Constitution cannot be taken away by the amendments by the Parliament. So these are the basic features, and the basic structure doctrine came out in 1973 through the judgment which is called the Kesavananda Bharati case. Through the Kesavananda Bharati case, Kesavananda Bharati case, the basic structure doctrine was introduced in India. And through the various judgments, different things are introduced as the basic structure of the Constitution. So there are many features which are fundamental or which are the basic structure of the Constitution of India. For instance, the parliamentary system of governance, judicial review. So the many features are there in the judicial in the basic structure, in the basic structure of the Constitution of India. You need to know all the points which are which constitutes the basic structure of the Constitution of India. So in this Chandra Kumar case, the basic judicial review was held to be the basic structure of Constitution of India. So that is important. And the issue involved here was whether the power vested under Article 323 to the Parliament under Article 323b to the state legislature completely excludes the power of all courts except the Supreme Court of India under Article 136 of the Constitution of India for dispute and claim under Article 323b. So as I just said, that whether legislature or the Parliament can exclude the courts for against the passing of the judgment of the tribunals. So this is the case. So this is being talked about here. And Article 136, this is again important. It talks about the special leave petition. What is special leave petition? Special leave petition is an special judgment of Supreme Court, where Supreme Court takes the recognition of the certain case which is to be taken in its own hand. ठीक है. So special leave petition is the condition where Supreme Court decides to pass verdict on certain case. ठीक है, whether that is through the appeal or through its own recognition. ठीक है. So Article 136 talks about the special leave petition. So this is the verdict. So power of High Courts and Supreme Court under Article 226 and Article 32. ठीक है. Article 226, as we all know, talks about the judicial review of the High Courts. ठीक है. Article 32. ठीक है. Article 32 talks about the judicial review of the Supreme Court of India. So the judicial review under Article 326 and 32 is not outside the jurisdiction of any courts. ठीक है. They are under the jurisdiction because they are the basic feature of the Constitution of India. So these three cases are very important. You need to know all of it. ठीक है. Now, why does the government use the money bill to pass the bills? So, as I just discussed in the initial part of this video, that the government who is majority in the Lok Sabha wants to pass the bill through various routes. ठीक है. They can pass a bill as money bill or the ordinary bill, but there might be case where the government is majority in Lok Sabha, but in Rajya Sabha they are not in majority. ठीक है. If the bill is passed in Lok Sabha, then that bill will go to Rajya Sabha, and if in Rajya Sabha the opposition parties come together and defeat that bill, will not be sent to the president for his assent. ठीक है. So the purpose of that bill will be defeated. But there is a catch. If the government of India, ठीक है, which introduces the bills, government bills, introduces bill as a money bill under Article 110 of the Constitution of India, then that bill will be introduced only in the Lok Sabha. ठीक है. And the Speaker of Lok Sabha has right to categorize certain bill as money bill or not. Only the Speaker of Lok Sabha. And to introduce the bill, ठीक है, to categorize certain bill as money bill or not is the sole responsibility of Speaker of Lok Sabha. ठीक है. So this is very important. Speaker of Lok Sabha, he has exclusive right over deciding whether certain bill constitutes a money bill or not. But the question is that whether the Supreme Court or the Speaker of the Lok Sabha has exclusive right to decide certain bill as money bill or not. ठीक है. Whether the power of Speaker to decide certain bill as money bill is outside the judicial review or not. ठीक है. So that is again a questionable point, because it is said that the power of Speaker to decide that certain bill is money bill or not is exclusive right of the Speaker, and that is outside the judicial review. ठीक है. But as per the Chandra Kumar case, everything, ठीक है, the judicial review, that is the judicial review under Article 32 and Article 226 is the basic feature. ठीक है. That means even the Speaker of Lok Sabha, the decision taken by Speaker of Lok Sabha is not outside the judicial review. ठीक है. So talking about the government, why does the government use the money bill to pass the bills? The reason is that we just discussed that if the government do not have the majority in Rajya Sabha, they will take the route of money bill, and that money bill will be introduced in Lok Sabha, and that Lok Sabha will pass the money bill, and that bill will be sent to Rajya Sabha, and if Rajya Sabha recommends some changes in the money bill, the changes might be incorporated by the Lok Sabha, or that changes might be rejected by the Lok Sabha, but it is not mandatory that Lok Sabha has to accept the recommendation of the Rajya Sabha, and the Rajya Sabha can only recommend some changes in the money bill, but Rajya Sabha cannot reject the money bill. ठीक है, there will be no voting against or for the money bills. ठीक है, only the members of Lok Sabha, Rajya Sabha can express the opinions. They can only give the opinions. They cannot vote against the money bills. ठीक है, so for this reason the Rajya Sabha can be bypassed. ठीक है, so for this reason government basically decides the money bill to be introduced in Lok Sabha, ठीक है, to bypass the Rajya Sabha. So this is the basic reason why government decides to introduce money bill, ordinary bill as a money bill. And talking about criteria for being a money bill, ठीक है, so money bill as we just discussed is discussed in Article 110 of the Constitution of India, and money bills are those bills which contain only provisions dealing with all or any of the matters specified in Article 110 subclauses. ठीक है, so only the provisions which is contained in the subclauses of Article 110 constitutes the money bill. ठीक है, and imposition, abolition, remission, alteration and regulation of any tax constitutes money bill. So this is again contained in the subclause of Article 110. And regulation of borrowing money or giving of any guarantee by the government, ठीक है, so this constitutes money bill. Custody of the consolidated fund of India or contingency fund of India, the payments of monies into or withdrawal of money from such funds is again money bill. ठीक है, and appropriation of monies out of consolidated fund of India, ठीक है, appropriation means whether taking out money or giving money in the consolidated fund of India is a money bill. Declaring of any expenses to the expenditure charged on the consolidated fund of India or increasing of the amount of any such expenditure is a money bill. And the receipt of money on account of consolidated fund of India or public account of India, or the custody of issue of such money bill or audit accounts of the union or the state. ठीक है, so audit accounts are also the money bills. So these are the provisions, ठीक है, which are categorized as money bill. No other thing which are outside the Article 110 subclauses are the money bill. But the question is, the bill such as the tribunals, ठीक है, to change the power of tribunal, Aadhaar Act, ठीक है, Prevention of Money Laundering Act PMLA, ठीक है, Foreign Contribution Regulation Act, does they account for the money bill under Article 110? Can they be defined? Can there be provisions which defines them as money bill under Article 110? So that is the question that the Supreme Court of India will decide in the upcoming verdict, which will be headed by the 7-judge constitution bench. ठीक है, so these are the provisions which are contained in Article 110 of the Constitution of India. ठीक है, and issues involved in passing ordinary bills as money bills. First is the erosion of separation of powers. ठीक है, so if the money bills are passed, ordinary bills are passed as money bills, then the ordinary legislative process would be affected. ठीक है, so that means the separation of power, which is the separation among the powers of 3 organs of democracy, which is the judiciary, ठीक है, then there is the legislature, then there is executive. So these are the 3 bodies of the democracy, ठीक है, judiciary, legislature and executive. So there is the check and balances in these bodies. ठीक है, for instance, if legislature passes the bill, that would be reviewed by the judiciary through the judicial review. ठीक है, similar thing happens with the executive. ठीक है, and legislature, when the bills are passed, they are implemented by the executive. So these 3 organs are very important, and they are called the 3 organs of democracy. And the doctrine of separation of power is given by the Montesquieu. So Montesquieu, who was a French philosopher, gave the idea of the separation of power. And as per the separation of power, all three organs have the powers in their own domain. Okay? So if money bills are passed as ordinary bills are passed as money bills, then judiciary has to interfere. And if judiciary interferes in the legislative matter, for instance, in Aadhaar case, in Puttoswamy judgment, Supreme Court decided that what constitutes the decision of the government, whether the government should cede the Aadhaar with the other bank accounts or the PAN card, etc. or not, whether the government has right to cede Aadhaar with other things, that is being decided by the Supreme Court. That means Supreme Court is going into the domain of the legislature or the executive. But as per the separation of power, the work of the executive is to implement the law. For instance, the Aadhaar Act was passed and Aadhaar Act was being implemented by the executive, and executive had decided that the linking of Aadhaar card is mandatory in all important schemes, government schemes. It is mandatory to link Aadhaar card with the bank account, etc. But that certain cases were nullified by Supreme Court of India, because they failed to pass the test of proportionality. So that means the Supreme Court of India is going into the domain of the executive. That is, the Supreme Court judiciary is interfering in the domain of the executive. So that violates the separation of power, doctrine of separation of power. So erosion of separation of power is one of the issues involved in passing ordinary bills as money bills, and there is threat to integrity and authority of these judicial bodies. So if the tribunals are the powers to appoint the chairman or the other members of the tribunals is given to the executive only, there will be threat to the judicial bodies, because there might be biased people who are sitting as the chairman. So the appointment process would be impartial, so that might affect the democracy itself. So for this reason, the tribunals, which are supposed to be the independent body, which are supposed to be the equivalent of the judiciary, will be in threat. So for this reason, this is again an issue in the passing ordinary bill as money bill, and there is questionable legislative process. So it is obviously questionable, because money bill is passed, ordinary bill is being passed as money bill to bypass the Rajya Sabha and authority of Lok Sabha speaker. So this is again questionable, whether the authority of speaker of Lok Sabha to pass bill as money bill is outside the judicial review or not. As per the Constitution of India, it is outside the judicial review, but as per the Supreme Court verdict, authority of Lok Sabha to categorize certain bill as money bill is inside the judicial review. That means Supreme Court can always review the decision of the Lok Sabha speaker. So status quo as per the Constitution of India and as per the judicial verdict varies. So this is again an issue. So these are all important issues that you need to quote in your answer. And way ahead, talking about the way ahead, judicial review and legislative integrity. While the British model allows no judicial review of the speaker's classification, the Supreme Court has maintained that judicial review is integral to the basic structure doctrine. So we discussed it, that the British Parliament allows that the judicial review, there should be no judicial review to the speaker's classification in British. So the India basically follows the system that is there in Britain. So in Britain as well, there is no judicial review on the decision of the Lok Sabha speaker to categorize certain bill as money bill. But in India, the Supreme Court verdict says the opposite. and protecting democratic processes. Using the classification to categorize bills as money bills diminishes the upper house's legislative role as legislative body. There is need to avoid this process. ठीक है. And the role of Supreme Court, ठीक है, it is crucial that Supreme Court takes the count of these things in its own hand. ठीक है. Supreme Court can decide on these things using Article 136 or Article 32. ठीक है. Role of parliamentary committees, ठीक है, every bills must pass the scrutiny of the parliamentary committees. And committee on categorization, ठीक है. So this is an innovative point that you can write in your answer. ठीक है. So parliament basically can form a committee which categorizes the bills as money bill. ठीक है. And it can include the members from the opposition parties as well as the ruling party. ठीक है. So these are the way ahead that you can write. Now moving on to next important topic, which is the NTA, which is National Testing Agency, and the centralized exams status. So this is an important topic because recently, as we all know, there is controversy which is going on about the NEET exam. ठीक है. So NEET exam was conducted by National Testing Agency, but there was a paper leak in NEET exam, and recently Supreme Court has also ordered to release the exams results. ठीक है. So there is the question that whether the NTA is whether the NTA has the integrity today or not. ठीक है. So integrity of NTA itself is questionable today. So context is National Testing Agency NTA has become controversial body today with the questionable integrity. So this article appeared in the Indian Express as well as the Hindu, and the background is in 2017 Government of India established the National Testing Agency. ठीक है. So National Testing Agency was established in 2017 to conduct the various exams such as the NEET exam, ठीक है, and other exams of UGC. ठीक है. So this was established, but after coming into effect of this NTA, various criticisms appeared in news, and the criticisms includes the implementation process, the widespread leakage of the question papers, ठीक है, manner of awarding the grace marks. ठीक है. Recently we have seen that a huge amount of grace marks is being awarded to the students, and conducting of the re-examination for just a handful of the students, etc. So these things are being criticized by the people. ठीक है. So for this reason this topic is in news. We need to understand what is the status of this NTA. ठीक है. So criticisms are basically that the NTA is going against the mandate. This is the first criticism. ठीक है. So mandate was that initially when the NTA was established, government said that the NTA will conduct the examination in online mode, basically in the MCQ format, which is the multiple choice question type examination in electronic mode. But nowadays that the going against the mandate of the NTA, the NTA is conducting the examinations in pen and paper based mode. ठीक है. So for this reason this move is being criticized by the people because this is against the mandate of the NTA, the establishment of the NTA. So there are 4,750 examination centers in examinations for the NEET exam, ठीक है, which is National Eligibility cum Entrance Test, ठीक है, for admissions in the undergraduate medical courses. So there are huge number of centers. ठीक है. For instance, for NEET exam there are 4,750 centers, but in these centers there might be paper leak if the examination is conducted in the pen and paper format. ठीक है. Huge number of manpower is needed, but the NAT or the NTA does not have the requisite manpower. ठीक है. So for this reason NTA there might be paper leak, and for that reason the integrity of the NTA might be questionable. ठीक है. So this is an important criticism, and another important criticism is the lack of specialist. So NTA was supposed to have the specialist, ठीक है, in the science of testing to set up the appropriate question banks and also evaluator frameworks and organizational expertise. ठीक है, there is need to have the expertise, ठीक है, but expertise is lacking in the NTA. This is another criticism. And outsourcing, ठीक है, despite conducting more than 15 entrance examinations which includes CUET which is the common university entrance test, ठीक है, for the central university admissions and postgraduate admissions and the NEET, ठीक है, despite conducting such high level of examination, NTA is outsourcing its functions, because as we just discussed that for NEET only there are 4,750 centers, but NTA has manpower which is less than 100, ठीक है. So these many manpowers will not be able to handle all these works of conducting the examination, and for this reason NTA outsource its work, ठीक है, to third parties, and in that process there might be some leakages in the papers, there might be some mishandling of the papers, ठीक है. So that is questionable. And another important criticism is that the NTA is being headed by the IAS officer, ठीक है. Although IAS officers has the experience in varied field, ठीक है, they have the experience in different backgrounds, they have the expertise, but it is being criticized that the IAS officer who are generalist in nature cannot head the specialist body like the NTA. So this is another criticism that you can write, ठीक है. So these are all important criticisms about the NTA, which is National Testing Agency. And government action. So what government has done, government has basically constituted a 7-member committee, which is the committee which is chaired by the Indian Space Resource Organization CEO, ISRO chairperson, the former chairperson of ISRO, not CEO, sorry, K. Radhakrishnan. So K. Radhakrishnan basically heads the committee to evaluate the NTA examination, the process of conducting the NTA examination. ठीक है, it has some terms of reference here. Reforming the mechanism of the examination process to forestall any possible breach, ठीक है, improving data security protocols, making recommendations on the structure and the functioning of NTA, ठीक है. So these are the terms of reference, ठीक है. So government has taken the action, but it will take some time to reform the NTA. But till that time, what government can do, what are the way ahead that is there to reform the NTA? First one is the review the process. Reports of the widespread cheating and the leakages in the examination conducted at national levels calls for the need to review the centralized testing mechanism of higher education institutions, ठीक है. So how is the leakage in such a high level of examination is going, ठीक है. So that has to be reviewed, the process of conducting the examination. So entire process has to be reviewed. And the decentralization is another important way ahead, because India is a semi-federal state, ठीक है. India is a state, India is said to be called the Union of States under Article 1, ठीक है. India, we cannot say India is a federal state or India is a centralized state, ठीक है, but India is a union of states. India has some feature of the federalism, ठीक है. So India, what India can do is that the powers of appointing or powers of conducting the various examinations for different tests, ठीक है, can be decentralized, ठीक है. The central government may restrict testing for entry to its own institution and decentralize where the states fill up their own seats on the basis of entrance examination, ठीक है. So states can conduct their own examinations for admission in the medical seats, to fill the medical seats in the colleges, to fill the seats in the engineering colleges, ठीक है. So the decentralization can be is one of the action that the central government can take. And there is this standard operating procedure, ठीक है, center can develop a standard operating procedure to ensure that the requisite standards are maintained for the test and evaluation framework. So if the central government decentralizes the function of conducting examination to the states, the central government can make the standard operating procedure, giving the guidelines to the states that the exams should be conducted in that way only. ठीक है, so SOPs can guide the states to conduct the examination. ठीक है, and there are the examination that 24 lakh students appear to fill 1 lakh seats are prone to be risky. So we just said that there are huge number of candidates appearing for various exams. For instance, in NEET there are around 24 lakh students appearing for these exams, but only there are less than 1 lakh seats. ठीक है, so to avoid these things, decentralization can be one of the option. ठीक है, so these are important way ahead. ठीक है, we can see other way ahead as well. There can be involvement of experts. ठीक है, testing bodies could be restructured to incorporate the domain experts, testing experts, and IT measures can be taken. Information technology, ठीक है, they can be safeguarded. ठीक है, so experts can be included there, and rejuvenate the schooling system. ठीक है, so integrity of national state level examination also in the spotlight. ठीक है, so standards of academic competency, hard work, and good values that are built up in the school level can never be achieved at the time of higher studies. ठीक है, so the overall education system, the way of imparting education in the lower level has to be revamped. ठीक है, we have to give the moral education to the students. ठीक है, so there is need to address that challenge as well. ठीक है, because the integrity of the state level examination as well as the national level examination is in the question. ठीक है, so the values has to be incorporated in the students. ठीक है, so that they consider that the cheating is not for the greater good of the students and for themselves. ठीक है, so that kind of value has to be taught in the schools. So these were all important facts about the issues in the know. ठीक है, now moving on to next important topic and the last topic for today, which is the takeaways from the SC verdict in the favor of Assam man in the citizenship case. So citizenship case is very important because the government of India had recently implemented the citizenship amendment rules recently. ठीक है, so for this reason as well this topic was in news, and recently another topic came that the Supreme Court last week declared the Assam resident Mohammad Rahim Ali as the citizen of India, throwing out the decision of the Foreigners Tribunal. So Foreigners Tribunal in Assam is very active, and the Foreigners Tribunal which is constituted by the Foreigners Act, ठीक है, is basically a body which decides whether some person is the foreigner or not. ठीक है, and Supreme Court of India recently quashed the decision of the Foreigners Tribunal in Assam. ठीक है, so this is the context of the news, and the facts of the case is that the Rahim Ali, who was born in Assam, could not produce the document which was required to be produced in the Foreigners Tribunal. ठीक है, there was minor mistakes. ठीक है, although Rahim Ali was born in Assam, but Rahim Ali was unable to produce the document. ठीक है, Rahim Ali was born in Assam. ठीक है, and he had the name in the voter list as well. Despite that, the failure of Rahim Ali to produce the requisite documents made him foreigner. ठीक है, because the Foreigner Tribunal in Assam declared him to be foreigner. ठीक है, so this decision of Foreigners Tribunal in Assam was declared null and void by the Supreme Court of India. ठीक है, and why was this declared null and void? Because Supreme Court of India basically said that the failure to produce the documents, minor documents by the Rahim Ali was not the criteria to be declared him foreigner, because there is the burden of proof which is there in the prosecution, not on the Rahim Ali. ठीक है. So basically Supreme Court of India in this case decided that there is reverse burden of proof. ठीक है. So this is an important term, reverse burden of proof. So this criteria was considered to be important factor, ठीक है, in this case. So in the reverse burden of case, what happens is not the accused but the prosecution has to decide whether the person has the right or not, ठीक है. So the burden of proof is in the prosecution, not in the accused in the reverse burden case, ठीक है. But what the section 9 of the Foreigners Act 1946 says is that the burden of proof lies on the alleged person, ठीक है, which is the accused person. So that means the foreigner tribunal was right as per the act, but the Supreme Court asserted that there is some wrong in the process, ठीक है, because the burden of proof has to be on the prosecution, ठीक है. So this is an important verdict which is against the Foreigners Act of 1946, ठीक है. So this raises the question whether the Foreigners Act itself has to be amended or not, ठीक है. And the clause 5 of the Assam Accord sets the January 1, 1966 as the base cutoff date of detection and the deletion of the foreigners, ठीक है. Assam Accord, as we all know, is an accord by Government of India and some people in the Assam, which is AUSU, to decide the cutoff date for declaring certain person who entered from Bangladesh to India as foreigners, ठीक है. And Assam Accord basically declared that the March 24, 1971 should be the cutoff date to declare a certain person as the resident of India, ठीक है. So if some person has entered into India from Bangladesh after March 24, 1971, that person will be declared foreigner by the Foreigners Tribunal as per the section 6A of the Citizenship Act, ठीक है. So section 6A, this is very important, was introduced as per the clause 5 of the Assam Accord, ठीक है. So you have to know this point. And Supreme Court rulings on the burden of proof, ठीक है. So Supreme Court ruled that the burden of proof has to be on the prosecution, ठीक है, that is the Foreigners Tribunal, ठीक है. So this is an important judgment. And what is the foreigner tribunal? What are the foreigner tribunal? So foreigner tribunals are basically the tribunals which are created by the executive order, ठीक है. So they are not created by the constitutional mandate, ठीक है. So foreigner tribunal were established in 1964 by the executive order of the Home Ministry, even though the Article 323B of the Constitution provides that the tribunals may be established by the appropriate legislature by law, ठीक है. So Article 323B says that the tribunals can be established only through law, ठीक है. But against this provision of Article 323B, the Home Ministry established foreigner tribunals through executive action. So that is again against the constitutional mandate, ठीक है. So that is again criticized by the people, ठीक है. And the Foreigner Tribunal Order 1964, ठीक है, it was enacted by the central government through the use of powers granted under section 3 of the Foreigners Act 1946, and Foreigner Tribunal Order 1964 gives the district magistrate the authority to establish tribunals, ठीक है. So district magistrate can establish foreigner tribunal in the districts, ठीक है. So earlier, before this amendment, ठीक है, Foreigner Tribunals Order 1964 amendment was made. Before this order came, the Ministry of Home Affairs established the Foreigners Tribunal, ठीक है. But now even the district magistrate can establish the foreigner tribunals in districts, ठीक है. So these are the provisions that you need to know about the foreigner tribunals. And there are important facts that you need to know, ठीक है. and you can quote these facts in the criticism of the Assam Accord or criticism of the foreigner tribunals as well. Okay, about 3 lakh people in Assam were declared doubtful voters in 1997, and in subsequent years by low ranked government officials without any inquiry notice. Okay, they were excluded from the Assam NRC, and they were now facing the foreign tribunals. Okay, more than 3 lakh people has been declared as the doubtful voters in Assam. Okay, and paragraph 3(1) of Foreigner Tribunal Order 1964 mandates that the notices shall mention the grounds. Okay, but nowadays the notices that is being given by the tribunals are not mentioning the grounds on which they are being arrested. Okay, so that is another criticism. And until March 2019, as many as 1.17 lakh people have been declared as foreigners. Okay, and many have been declared foreigners without valid grounds. Okay, and many have been declared as foreigners due to minor discrepancies in the papers as well. Okay, so this judgment of the Supreme Court is landmark, because this judgment has given the scope to the people of Assam that the burden of proof is not on the accused but on the prosecution. Okay, so this is an important verdict that you can remember. Okay, so significance is that the judgment will reduce the anxieties of many people, okay, who have been excluded by the NRC or the Citizenship Amendment Act of 2019. Okay, so these are all important current affairs that were there in past 3 days, and these things are very important. All current affairs that I discussed today are going to be very, very important for all of you. Okay, so I'll be covering the current affairs of next week on Wednesday. Okay, I'll be coming up with the current affairs next week. So till then, study well. Okay, practice as many as MCQs as possible. Okay, mains are also near, and prepare well for the mains. Try writing more answers every day. Try revising everything on time. Okay, try to manage time. Revise your optionals as well. So having said that, I wish you all the very best for your mains. Prepare well. Okay, so having said that, I'm concluding today's session. We'll meet again in the next video. Till then, take care.